Greetings, everyone. Thank you so very much for joining us today. My name is Catherine Fleming Bruce, and I am the CEO of this organization that's bringing all of these folks together. Our organization is called Camelot Excalibur Trust, and our job is to look at many of the issues of the day and try to bring them in line with what the community is interested in, try to answer their questions about it, bring guests that can elaborate and expand upon what they might read in the press, what they may have heard, or if they're not aware at all, we're also here to make sure that happens. This is an election year, 2024. So there are many issues about voting and candidates that we're also paying attention to. This particular issue that we're talking about today combines some of those issues, but it also goes back to the things that are important to us: accountability, transparency, and how our government works, how each branch of our government works, and what the principles are that make it important for us to maintain principles, maintain a set of ideals, for our country. So that's why we wanted to look at this particular case today. We want to look at a case as we did a couple of months ago. A couple of months ago, we looked at a case called Alexander versus NAACP. And during that time, I had the opportunity to contact a friend who is a historian, Dr. Vernon Burton, who had worked with other historians to do an amicus brief. And so we had the opportunity to listen to the voices of the historians in that brief and how they argued in that, for or against in that case. So when this case came up before the Supreme Court, Trump versus Anderson, again, there are many briefs that have been presented. And once again, Dr. Vernon Burton's name was among those who had submitted an amicus brief. And so I was able to reach out to him to say, we would really like to find out if you would be willing to bring those historians into a conversation to talk to us about what the brief is about, why the public should know about this brief, what the arguments are being made, and what the basis is for those arguments. So fortunately, because the time is very short between today and the date that the Supreme Court hears the oral arguments, that will be February 8th. So a little less than a week from today, the Supreme Court will hear those oral arguments. So today, we have managed to get a large number of the 25 historians who participated and signed on to this amicus brief. And so I want to give each of them the opportunity to talk a little bit about what's important to them in this brief. But I'm going to start with the two who worked to bring everyone together around this material, Vernon Burton and Allan Lichtman. So let's start with Vernon and give us a summary for those who have not read the New York Times, have not listened to NPR or The Guardian or any of the other media that have paid attention to this case. Give us a little bit about the case and why the historians have decided to put this brief together.
Well, in my particular case, I had done a book, The Age of Lincoln, and I had argued that during Reconstruction, the violent overthrow of Reconstruction by terrorist and paramilitary group, that most white Southerners, former Confederates, did not participate in that. That the real tragedy was that they did nothing and allowed the rule of law to be overthrown. And then later, I find myself in a parallel, what I see as crisis of democracy that we're living in now. And I ask myself, what can you do? And what we can do as historians is do history. So when Allan asked me to help him, we had worked together over the years in voting rights cases, going back to Mobile versus Bolden in 1980. Then I was happy to try to do this. And despite the way the media has presented it, saying historians say that Donald Trump cannot run or whatever, we never say that. Both Allan and I were committed to doing a brief from historians about the history. Here is what the intent of the stakeholders were at that time and how it was perceived. And with that little brief introduction, I'd like to turn it over to Allan, who really worked day and night to get us a draft of this brief that I think is important. And it is important because we are the experts. We're the historians who study this period. We look at the evidence, and evidence is central. You have to have evidence. This idea of alternative facts is nonsense. And we have seen the Supreme Court now in some terrible decisions create their own history. And at least they have to now deal with what people did at that time and thought they were doing and how they intended it. Allan, I'm going to turn it over to you.
Thank you so much. Indeed, we steered clear of the politics. We didn't jump the legal issue, but we gave the U.S. Supreme Court the best available historical analysis of what is the meaning of Section 3, the disqualification clause of the 14th Amendment, based upon contemporary evidence and professional analysis. And here's what we came up with. Number one, that Section 3 covers the president. That was the central argument of Trump, that I'm not covered. In fact, this issue was directly raised in 1866 during debates over the 14th Amendment when Senator Reverdy Johnson of my home state of Maryland, an opponent of the 14th Amendment, says, why doesn't it cover the president? He's not mentioned. And then Senator Lott Morrill, a strong supporter of Reconstruction and the amendment, said he is covered as an officer of the United States. Johnson then said, oh, I'm corrected, and no senator arose to challenge that. And there's the very interesting case of Jefferson Davis. In 1872, Congress was debating giving ex-Confederates amnesty, but they refused to give amnesty to Jefferson Davis because they were afraid he would run for president of the U.S. They recognized that Section 3 covered the president, and under Section 3, Davis could not run for president, but if they gave him amnesty, he could. Second point we made was by putting it into the Constitution, the framers of Section 3 clearly meant it not just to punish ex-Confederates, but to guard against future insurrectionists. They could have punished ex-Confederates just by statute, and they rejected versions of the amendment that limited its scope. Third, we pointed out, again, based on contemporary evidence, that the amendment, just like qualifications on age or residence or birth, is self-executing, did not require an act of Congress or even a conviction. Thousands of ex-Confederates were automatically disqualified the day the amendment was ratified in 1868, including Jeff Davis, who then ironically argued, yes, I was disqualified for running for president, but that should quash my treason prosecution because it's double jeopardy. That issue was never resolved, but no one disputed that he was disqualified, even though he wasn't convicted of anything. There was no act of Congress. He was disqualified the day it was passed. These are critical historical issues that we believe, whatever the justices do, they must take into account.
Now, I'd like to hear, I had a conversation with each of the historians here. And Brooks had something very interesting that he wanted to make sure that we went to. So why don't you put that in, Brooks?
Thank you. Good evening, everyone. We were talking very much about the fact that if you are bound in interpreting the law by a notion of textual analysis of original intent, then you have to, in this case, look at what the participants at the time said. And in fact, these people in 1866 were very clear as to what they meant. They spoke about these things before, as early as the Second Confiscation Act in 1862. They would speak about it again in 1872, and even in a proposal in 1876 concerning Jefferson Davis. So in other words, if we're really going to respect the historical record, the mission of this panel of historians is to uncover what that record said with empirical evidence that was embodied in the text of arguments, debates, etc. And that's really what we did. If you want to say, what did the 14th Amendment mean? What did the section mean according to the people who framed and passed it? Well, we have, to the best of our ability, recovered what that intent was, what that meaning was. And a Supreme Court, which often says that is guided by the notion of original intent, cannot sidestep the information contained in this brief.
Here, here.
Thank you. Thank you so much. And I know that there are another set of historians who did a different brief, but one of the additional links between this group and that group is a citation of the work of one of the scholars that's here. So Manisha, you want to talk about that book?
Thank you, Catherine, for having us, and thank you, Allan and Vernon, for putting together the brief and having us all sign this. Yes, it so happens that I was asked to sign both briefs, and I signed Allan and Vernon's first, and I was then told that you cannot sign two amicus briefs for the same case, which, being a naive historian, I did not know. I had signed amicus briefs earlier. So the second one, that is written mainly by Jill Lepore, did cite my forthcoming book, and I think she did that because she blurbed it, so she had actually read an advanced copy of it, because the book won't be out until March. The Rise and Fall of the Second American Republic. It's a new history of Reconstruction, and I think I'd just like to reinforce some of the points already made here. One is that Section 3 clearly applies to the President of the United States too, precisely for the reasons that Allan evoked from the debates in the Congressional Globe over the 14th Amendment, but also because the President, like other federal officials, has sworn an oath of office to uphold the U.S. Constitution. And the Section 3 very clearly says that if you have held office and sworn an oath of office to uphold the U.S. Constitution and then incited or participated in an insurrection, then you are disqualified from holding federal office. Now, mind you, this was not applicable to all Confederates. It was to Confederates who had held federal office, like Jefferson Davis, who was Secretary of State, actually. He was in Buchanan's cabinet before he became president of the Confederacy, or Alexander Stephens, who was a senator from Georgia. So it was very specifically actually targeting high office, people who had actually held those federal offices and sworn the oath. And there is a way out. If people said, well, this is against democracy, why shouldn't Trump be allowed to stay on the ballot? Well, there is a way out. You could get an amnesty, as was passed in 1872. By the act of Congress, you can be pardoned. The second thing that I think the second brief and this brief does very well, as Allan already mentioned, which is the people who wrote the 14th Amendment were quite clear that they were not just passing a federal law, they were passing an amendment to the Constitution that would be permanent, that would be the fundamental law of the country. And in that, they visualize its use in the future. And this was true of the Equal Protection Clause, because one of its authors actually says, I cannot imagine how it would be used in the future by future groups of citizens. But it uses broad egalitarian language precisely for that reason. Similarly with Section 3, Allan's point that it visualized not just punishing ex-Confederates, high office holders who had betrayed their oath of office to the US Constitution, but also for the future, in case this arises again, because they were seeing how many former Confederates in the South were refusing to accept the results of the Civil War and emancipation, even after all that death and devastation, that they were still contesting that. And so I think that's also really important to remember. And I think both the briefs sort of complement each other in that sense. They reinforce these points, not as a matter of, sort of axe grinding by historians, but saying this is the exact historical context that the authors of this amendment actually visualize for the future. And as Brooks put it, many of our Supreme Courts, I don't believe in that theory of constitutional interpretation, but they think of themselves as originalists of original intent, then they should know what the original intent is. And if you're not going to follow the original intent, then you should say so, that your reasoning is political and not based on any constitutional principle. So I simply want to reinforce what has been said before.
Manisha, you are so eminent, they should have let you sign both of them.
I am not as well, Allan. I don't have your record of predicting the correct victor of a presidential election. I think you were one of the few who predicted that Trump would win the Electoral College. So
I've been doing it since before you were born.
I am very old, Allan.
I wanted to say, and we also have Paul Escott here, who studied both Jefferson Davis and some of the other also, but we look at the Civil War and think about it, but John F. Floyd was Secretary of War in the Buchanan administration and was a traitor. I mean, this is what people were looking at as well. And it was about having taken an oath. And in this case, they were trying to keep Lincoln. I mean, it's so similar. They were trying to keep Lincoln from being inaugurated.
Yep.
So even another parallel there, people tend to think about it as a civil war, but it starts earlier. They have in mind these people who both of these folks have said had taken an oath and then betrayed that oath deliberately. And we have Brooks too, who did Grant, and Grant made it very clear about it being self-executing, telling the generals like Canby in Virginia, you self-execute who is going to or not. So there's so much there. But Paul, I thought you might want to say something, having early in your career studied Jefferson and recently studied a bunch of Democrats at this period. So,
well, I would add that in understanding what Congress and the writers of the 14th Amendment had in mind, we can see too that in 1867, when the amendment had not yet been ratified, Congress made clear that this disqualification applied to anybody who wanted to be in the new governments that were being organized in the South. People who had sworn an oath and then had engaged in insurrection or given aid and comfort to it would not be able to hold office. In our comments prior to this moment, we hadn't mentioned that business about giving aid or comfort. And I think that's a very relevant section of the 14th Amendment, Section 3 as well. So we can keep all of that in mind. And it's another point within the many that Allan and Vernon and the rest of you have made for this good brief.
and I know Hillary is looking at particularly after the Civil War and during Reconstruction. And one of the things we put in, I think that's very important to remember, is once people like Wade Hampton in South Carolina or others, once these people in Mississippi who had been, in fact, because of violating their oath, not allowed to run for office and participate, when they get in office again is when you have the beginnings of Jim Crow, the disfranchisement, the segregation all comes about, that there are consequences. And I think that almost shows the foresight that the original people who are doing the 14th Amendment understood what could happen. It's almost as if it were predicted once these sort of amnesties came in. So I think that's fascinating. I didn't know, Hillary, maybe you want to speak.
Yeah.
Not because we create this whole myth of Reconstruction. It's not true that we still have today.
And I think that's what's important. And I just taught the 14th Amendment in my classes. We read the entire amendment. We don't cherry pick with section 1. We read all of it because it's when those individuals like Wade Hampton and others get that amnesty and then come back and then issue out Jim Crow that you start seeing African Americans who lived through the amnesty, who lived through and fought in the Civil War. They're arguing both section 2 and 3 to try to get rid of these people for, okay, you did this. And again, you're also violating this very act that you said you weren't going to do. And so one of the things that I think is very, in particular, that my students never pay attention to is that aftermath. And we look at that language very carefully and we read the debates and we read that they're talking about for future, not just what's happened with the Confederates, but future. Because if they wanted to, it could have been statute only. It's in the Constitution and that amendment stays. And all the parts of amendment stays. And it says in very much in section 3, but Congress may by a vote of 2/3 of each house remove such a disability. That has not happened, and that language is clear. And that's one of the things that African Americans and other activists will start to protest. Like, okay, we have the Amnesty Act, but now they came back in and they're doing it again. So what kind of work are we doing? So one of the things I want to say about this brief that I really liked was the Chase, the 18 Chase bill, and what he said, it applies to all offices. You do not need a conviction. And all those parts of the amendment still are on the books. So if you're going originalist, you have to go back to the original intent, read those congressional records that are very much public and widely available, read the entire amendment. You can't go back to 1787. You have to read Reconstruction. And there's a reason why my students only read section 1, because that's all they were taught. Most Americans don't know that there's more than one section. So what do we do? And as historians, we teach, and we teach what is in our US Constitution. And that is where section 3 and all the other sections of the 14th Amendment matter.
Here's one of the great ironies that we point out in our brief, that these ex-Confederates got amnesty, which authorized them through an act, as Hillary points out, of 2/3 of both houses of Congress, authorized them to vote and run for office. So what do they then do? They snuff out the right of African Americans to vote and hold office. You know, it's just extraordinary, the consequences of this.
And the parallels today, I think we have two experts with Harry and Eric on parties. And we're in such a incredible partisan situation today that I think they could add something too about the party system and how all of this comes about.
Well, thank you very much, Vernon, and thank you, Catherine, for having us. This is a very stimulating group.
Yes.
Discussing a very stimulating brief. And I say that's because I didn't write it. It was Allan and Vernon. One of the things that has most concerned me about the discourse concerning the situation we find ourselves in and the discussion about whether President Trump should be disqualified for running for office is the opinion of a lot of people whom I respect and who are very thoughtful and well-informed, who say that, listen, it is not up to the courts to pick the president of the United States. It's up to the people. Therefore, we should let them vote on whomever they want.
Mhm.
And what that means essentially is that Section 3 should be ignored. Let's just drop our attention to that, turn our eyes and pretend it's not there and just go forward. And that alarms me very much if that were ever to become generally accepted, because it's of course true that the people should choose the president of the United States. However, the people do not have the right to pick the president without following any rules. Instead, they've bound themselves by the US Constitution to follow a certain code of law, a certain rule book in choosing the president of the United States and so many other things. And the 14th Amendment is part of that corpus of law that we have to respect. Now, think about what would happen if we all decided that the 14th, Section 3 of the 14th Amendment just didn't count this time, and we could ignore it and have a presidential election and disregard whatever it is the text of the Constitution says. Well, the result of that is we would not have a Constitution anymore. Because if you allow that, then there's no reason why people can't vote away the First Amendment if they want to, or they can establish a religion or do anything that the Constitution forbids, because after all, it's the people, they get to vote. Well, that's called a plebiscite kind of self-rule, and it's been the tool of dictators for centuries, really, and because those votes can be so easily manipulated. Instead, we have to realize that if we use a popular vote to abrogate one part of the Constitution, then the popular vote can abrogate any part of the Constitution, and it means we do not have a Constitution anymore. And I don't think any of us want that, but I think we have to call attention to where those falling dominoes point if we were to stand aside and let this happen.
Adam,
I can
you were,
interject.
yeah, Adam, you studied in your dissertation these very people, and then you wrote about the lost cause following what Hillary did. I think you could probably really add some insight.
Well, if I could, yeah. I mean, picking up where Dr. Watson left off, the great irony of the argument that we should allow the people to choose is the reason we got in this situation is when the people chose, Donald Trump did not want to respect that decision. That is why he's no longer eligible, according to many legal scholars, to run for office, is because we did have an election. He had his chance and he lost. And so to say, all right, we got to let him run again. Well, no, because he didn't respect the results the first time. And as we sort of think about this, when we think about the people who were disenfranchised, you often hear original intent. This is going towards a different direction, but original intent, when you read these decisions, is a lot of times cherry-picked quotes. And this is one of the few times when the original intent is actually quite clear and quite agreed upon. Now, normally when you're looking at original intent, you have issues where, well, not everyone agreed when they signed the thing. So you're just cherry-picking the quotes to get it to mean what you want. But in this case, there were literally hundreds, if not actually probably thousands of individuals who did not have the right to vote, accepted they did not have the right to vote, and lobbied to get amnesty because it was self-executing, right? Is you didn't need to be convicted. The idea that you had to be convicted, well, why did all these thousands of white Southerners across the Confederacy, the former Confederacy, during Reconstruction, either not even bother to register to vote or were turned away when they tried to register to vote successfully. They were turned away because everyone understood that it did not take conviction. It did not take the court. It was a law that was to be enforced. There was not a singular enforcement mechanism. In fact, during the Reconstruction Acts, if you look at it carefully, they use the language of the 14th Amendment. They literally say, we're using this amendment that's coming down the road. It's not here yet, but use this language. And the enforcement mechanism, when it's being used at that moment, is the US military. They're enforcing it. And it's civilian voter registers across the Confederacy, the former Confederacy, are rejecting individuals who try to vote. And so the US military is the first enforcer in many ways of what becomes the 14th Amendment, not the courts. And so the idea that you have to have a conviction or you have to have a court say that he committed insurrection, that's not how people understood it. And that intent wasn't debated in the 1860s. It was very clear.
And Grant, you know, as president and knowing the military, was very clear on that too. Eric, did you want to jump in?
Yeah, we want to make sure he's.
Yeah, no, thank you, Vernon, and thanks everybody. It's such a pleasure to be part of this. I have a couple of different thoughts kind of picking up on various strands. I would say on the original intent point, to build on what Adam has just said really well, a lot of the originalists or the proclaimed originalists will get around the original intent and say, well, we don't really care about debates. We care about the plain meaning of the word at the time. And even in this case, I mean, there's another brief that we haven't mentioned yet, and that's another really talented and excellent historian, Mark Graber, who submitted a brief. Mark wrote a really excellent book that came out last year about the 14th Amendment and its emphasis on punishing treason. And in his brief, Graber points out that if you look at the original meaning of insurrection at the time, it meant very clearly a wide range of activities, including sort of small public gatherings, attempts to interfere with government activities. And insurrection wasn't just taking up arms. It can include a whole wide range of efforts to protest and fight back against the government. So I think, you know, no matter how you look at this case, whether we look at our brief and the and what was being said in the debates, or whether you look at the plain meaning of what an insurrection was at the time, it's very clear where, if you're using proper history, where the argument should fall. And Vernon mentioned earlier parties, and I think that was a good point as well. And, you know, what I'm struck by, and what I'll add to this conversation, is that it's an important reminder, I think, that progress is not linear. And I think, as all of us who've written about Reconstruction know very well, that you can make progress and then very easily backslide if you're not vigilant to maintain that progress. And I think we're seeing that now as well in the last 10, 15 years. You can pick any number of different cases and see what that means. And so during Reconstruction, I mean, so much of what many of my colleagues here have written about so beautifully and well and powerfully about the violent overthrow of Reconstruction in the South, which is the main part of the story. But even in the North, where you have Northern Democrats who are also fighting it back. And so we talk about the 14th Amendment, the chicanery that Northern Democrats got up to try to prevent ratification, using parliamentary rules and procedures in state legislatures to avoid actually ratifying the amendment. So for me, this brief is really important because I think, as historians, as Hillary said, through our teaching, and then through kind of our public voices, to remind us that we have to be vigilant. We have to push back and prevent backsliding and losing progress, which is a real danger, I think, in the past and in the present.
I want to say we would have loved to have Mark Graber. We also sent our stuff to him, and Allan had drafted it that he could use. But as Mark said, one of the unique things, and I keep stressing this, we all have PhDs in history. He has a law degree and a PhD in political science. But we are the historians, and history matters. You know, I am fond of saying that two things changed the American South. My particular area of interest, and yet it's the Voting Rights Act and air conditioning, and we understand how air conditioning works better because people believe in STEM education, and I'm all for STEM education as well, but so is our history, or what we used to call civics. And we have not done a very good job of that. And I want to get back to others, but one of the things that really struck me when Allan asked me to help him with this, and that was my study of Lincoln, who truly believed in the rule of law that he struggled with. You go back to his Lyceum speech. I remember, 20, 30 years ago, you and I were discussing this, Brooks, in Springfield. And I sort of think he refines that speech until he gets to these great things like, the Gettysburg Address and the Second Inaugural, but it's the same idea. On one hand of liberty, total liberty, you have anarchy. And on the other side, you have authoritarianism, monarchy, hierarchy. And I don't mean to frighten people, but I believe it. We are once again in an era of where authoritarianism is popular in the world, just as it was in Lincoln's time, where we had come back, where the Confederacy was much more in line with the rest of the world. And it was United States, which was an outlier when Lincoln said the last best hope, because of that balance. And that balance for the rule of law for him was the Constitution. It's just what people have said here. You can't cherry pick the Constitution. If you do, what do we have left? There is no rule of law. And how can you hold a society together without trying to go either toward authoritarianism or total anarchy, unless you have that? And that's that rule book that I believe very much that Lincoln was responsible for taking that 13th and 14th and 15th Amendment, those three amendments, changing the Constitution, putting, in fact, our mission statement into the rule book, the Constitutional Declaration there. And that's what we're dealing with now, reading that 13th and 14th, 15th Amendment just as broadly as people read the First and Second Amendment. We're asking for consistency.
I'm going to take a minute to quickly read through a list of the scholars who contributed either through their work or by being a signatory on this brief. So I want to make sure that I get that in, of course, and some of them are here and some of them are not, but I want to read the whole list of names. Of course, there's Vernon Burton, Judge Matthew Perry, Distinguished Professor of History at Clemson and University Distinguished Teacher Scholar Emeritus at the University of Illinois. Allan Lichtman is the Distinguished Professor of History at American University. Nell Painter is the Edwards Professor of American History Emerita at Princeton. James McPherson is the George Henry Davis 86th Professor Emeritus of U.S. History at Princeton. Manisha Sinha holds a Draper Chair in American History at the University of Connecticut. Eric B. Alexander is the Associate Professor of History at Southern Illinois University, Edwardsville. Sean Lee Alexander is Professor of African and African American Studies at University of Kansas. Karen L. Cox is Professor of History at the University of North Carolina, Charlotte, and the 2024 Lewis P. Jones Professor of History at Wofford College. Adam Dombey is Associate Professor of History at Auburn University. I got that right, Adam? Adam?
Yeah.
You got
Okay.
it right.
Good. Yeah, just want to make sure because I didn't previously. Paul Escott is the Reynolds Professor of History Emeritus at Wake Forest University. Terrence Finnegan, Professor of History at William Patterson University. Hillary N. Green is the James B. Duke Professor of Africana Studies at Davidson College. Steve Hahn is Professor of History at New York University. Peter C. Hopper is Distinguished Research Professor at University of Georgia. J. Morgan Kosser is Professor of History and Social Science Emeritus at California Institute of Technology. Lawrence McDonald, Associate Professor of History at Iowa State University. Scott Nelson, UGA Athletic Association Professor of History, University of Georgia. Kenneth W. Node is a Drawn Professor of Southern History, Emeritus, Auburn University. Lawrence Powell is a James H. Clark Endowed Chair in American Civilization and History Emeritus at Tulane. George C. Rabel, Charles G. Summersell Chair of Southern History, Emeritus at the University of Alabama. David Roediger is the Foundation Distinguished Professor at the University of Kansas. Brooks D. Simpson is the ASU Foundation Professor of History at Arizona State University. Harry L. Watson is the Atlanta Distinguished Professor in Southern Culture, Emeritus, Department of History, University of North Carolina, Chapel Hill. Thomas C. Holt is the James Westfall Thomas Distinguished Service Professor, Emeritus, Department of History at the University of Chicago. And Thomas J. Brown, History Professor at the University of South Carolina. So I wanted to make sure we got the names in of all the folks who had done this hard work.
And Allan and two other people were starting to say something, Catherine.
Yeah, I just wanted to follow up a couple of things that Professor Watson and Vernon had to say. You know, in one of my other hats, I wrote a book called The Rise of the American Conservative Movement. And one of the things I observed was that for a very long time, conservatives posed themselves as the great guardians of the strict construction of the Constitution, that we can't go beyond what the Constitution requires, no matter what our ideology or views may be. And now they seem to have turned that on its head and instead said, you know, we don't like this provision. We think it's politically unpalatable, and somehow our support for the strict construction of the Constitution has gone out the window. And who for 5 years perpetrated the view that Barack Obama cannot serve as president of the United States because constitutionally, however falsely, he was disqualified because he was born outside the United States. It's a constitutional requirement, no different than Section 3 of the 14th Amendment. It happened that, of course, this was false, but for 5 years, Donald Trump is claiming we have to follow the Constitution, and regardless of the fact that the people voted him in, he should not be able to serve as president. And Trump's allies even took that argument to the courts, where it got fundamentally rejected. Finally, as Vernon pointed out and Hillary made so clear, and others, this is not an academic exercise. This is not just some kind of exegesis of the Constitution. This has real consequences, as we saw with the pardoning and amnesty for the ex-Confederates. You return insurrectionists to office, and our democracy is in grave peril. Democracy is precious, but like all precious things, it can be destroyed. And for decades, ex-Confederates who went into these Southern governments contributed to, in effect, destroying democracy in the American South. And it was only really recently, with the passage of the Voting Rights Act and the Civil Rights Act of 1964, that democracy began to be restored. You know, Donald Trump has said, I'm going to be a dictator on day one. Well, you know what? We're historians, and we know if you're a dictator on day one, you're a dictator forever. No dictator has ever given up their powers. So this is real. You know, this directly affects the survival of our precious democratic republic.
And one of the things, go ahead, Paul.
Sorry,
I thought,
I just wanted to, oh, sorry.
go ahead, Manisha.
No, I just wanted to reinforce that point that Harry first made about we are living in a constitutional democracy. And I think Allan also just reinforced that now that, you know, if we are not going to pay attention to constitutional requirements to run for the office of the presidency, then I could run for president, and I'm not born in this country, right? There are certain requirements, you know, you have to be over 35, you have to be born in this country. And now with Section 3, we know if you committed treason against the United States government, you are automatically disqualified. And as Thaddeus Stevens said, you know, never have traitors felt the hand of law more lightly, because they were not disqualified from voting. They were disqualified just from holding office. The Reconstruction Acts did disqualify Confederates who refused to take the ironclad oath or couldn't take the ironclad oath from voting. But Section 3 of the 14th Amendment doesn't do that. And I also wanted to reinforce something that Hillary said, that we have to teach all of the 14th Amendment. I mean, it's a sleeping giant. And if we did, we could protect our constitutional democracy. For instance, one of my favorite sections of the 14th Amendment is that if you indulge in voter suppression, right, you lose representation in Congress.
Yes.
Now, if the 14th Amendment had been enforced, the southern states should have lost representation in Congress for disenfranchising Black people with their new state constitution starting in the 1890s. They never were. They never paid the penalty for disenfranchisement, which meant, as Allan said, a regime of racial apartheid, no democracy really in the South at this point. So this question of enforcing or living within the limits of our constitutional democracy, enforcing the rule of law. The other example that Vernon gave was of Lincoln, and the idea is let the people decide. And I would refer people back to the slavery controversy and the difference between Lincoln and Douglas, when Douglas said popular sovereignty, let white citizens vote slavery up or down. That's the democratic way. And Lincoln said, no, that's not the democratic way. The federal government must actively prevent the expansion of slavery. Because we live in a country that honors certain basic ideas about human rights and natural rights. And so I think we really need to think about these things in the long historical context, and to argue that somehow we are subverting democracy by following the Constitution, I think is the kind of argument that a lot of pro-slavery people and their allies were making in the name of, quote, white man's democracy in the 1850s.
Now, I want to take a moment to give Adam any last moments to make a comment, if he would like to, because I know some of the folks have to follow some other schedules. Any closing remarks?
I don't have any closing remarks except to say that, it is an absolute honor to be have been asked to help participate in this draft with the scholars who I'm alongside of, who I'm in awe of, and I hope to one day be as good scholars as they all are. But their abilities have meant that this is a really good piece of historical work, and the history is clear.
Okay, so clearly we want to keep Adam around since he says such nice things about the rest of us. But let me go back to a couple of things about why there was a 14th Amendment in the first place. That is because in 1865, under President Andrew Johnson, white Southerners, first of all, took oaths of pardon and amnesty. You don't take saying, I did something wrong, unless you admit basically you did something wrong. And then these people were immediately elected to office. And sometimes, in fact, they were elected to office and then President Johnson pardoned them to keep them in there. Benjamin Humphreys in Mississippi, for example. So when Congress met in December 1865, it took measures to undo much of what Andrew Johnson had done, because people believed that the so-called fruits of victory of the American Civil War, including Black equality, were at stake. And most importantly, Black equality. Why were you restoring these rebels to power so quickly? Andrew Johnson proved very adept at trying to issue presidential vetoes. So one reason you have a constitutional amendment is because constitutional amendments cannot be vetoed. They cannot be blocked by executive obstructionism, which was probably Andrew Johnson's greatest skill as chief executive. And so this is that background, that they understood that what they were doing was engaging in changing the fundamental law of the land, not just simply passing statute legislation. They'd already done that. Civil Rights Act of 1866, other proposed legislation like later that year, the Freedmen's Bureau Act of 1866. They understood what they were doing. The other thing I think, and this goes back again and again to an issue of asking people to be as good as their word and be consistent in their interpretations of a document they claim to hold dear. We hear all the time about originalist interpretations of the Second Amendment to the United States Constitution. Even though many times that amendment is only quoted in part and not in whole. But if you are going to hew to a claim that we should engage in an originalist interpretation of the Second Amendment as you see it, then all we ask is that you be as good as your word and hew to an originalist interpretation of Section 3 of the 14th Amendment.
And I would add to that that people seem willing to read the First and Second Amendment as broadly as it can be, and the 13th and 14th and 15th as narrowly as it can be. And to follow up, whatever happens, we have again and again mentioned the vote, and that is so important. I really think authoritarianism has to be defeated at the ballot box. I hope it will be. I think we have to follow this, but at the 13th, at the time of the 13th Amendment, at the time when North Carolina was to be readmitted to the Union, Andrew Johnson, the cabinet was evenly divided on whether to admit states back in with the 13th Amendment. They had to accept the franchise of Black men. But Andrew Johnson, a native of North Carolina, though he's called the Tennessean, literally put in the grandfather clause that became the pattern for the South there. We are not a parliamentarian form of government. A lot of people seem to think we are. It's a winner take all with the presidency. And that president gets to appoint not only the Supreme Court justices for life, but those federal justices who make decisions that affect your children and your grandchildren down the line forever. So that vote is so important. And people have always understood that is why they disfranchised and kept Black people from voting in the South as well. So this is where it all comes down to, I think, whatever the justices do, no matter not telling anyone how to vote, but if democracy is going to work, people have to vote, and we hope they will understand the importance of their vote and what that means in terms of the Supreme Court, who rules on issues just like this to protect our Constitution and our democracy as a way of life so we can continue to be the last best hope. And all its imperfections, which I admit there in the democracy, I still believe that the United States is our last best hope, as Lincoln did. And if we don't follow this rule of law, just like several people have said here and emphasized, what do we have? We're going to cherry pick the Constitution. Then it's the anarchy that Lincoln talked about, or it's the authoritarianism on the other side.
I would like to expand on that and on the point Eric made, that progress is not linear. Lincoln spoke eloquently about the fact that our democracy is not perfect, but that repeatedly we need to make steps forward and keep pushing forward to realize the ideals on which the country was founded. And in my study of racism during the Civil War era, it's very plain that as progress occurs, there's always a backlash. And we are living in an era of backlash right now. If we hold true to the Constitution and to the 14th Amendment and what it meant and what it was intended to mean, we can avoid some of that falling back as happened in the 19th century.
And I love the phrases in Lincoln's two greatest speeches, and did a conference out of this where he talked about his unfinished work, our unfinished business. And I think this is exactly what we're facing right now at this time. Lincoln's unfinished work and unfinished business, which I took as race. You can take it other ways. David Rogers thinks it's labor, but right now our unfinished business is this 14th Amendment.
Well, I want to give everyone a chance to make a few final closing thoughts that tie into what we've just heard from Brooks and Paul and Vernon. And Adam has already made his closing statement, I think. So Eric, Hillary, Manisha.
Sure, go ahead, Hillary.
I was going to say, one of the things I think about the 14th Amendment and why I go back to the Reconstruction Amendments, I grew up hearing never again. I grew up studying people who came out of slavery, who fought for this country, who fought for these amendments, who fought for a new world out of what was the Civil War and what was possible. This is our never again moment. Are you going to be bold and brave? Are you upholding the Constitution? I uphold this. I still have faith in this country because we are striving for a more perfect union if we go back to our preamble. So for me, the 14th Amendment in its entirety, the original intent is clear. This is where you have to read the entire amendment, and also the jurisprudence of this amendment is very clear at the time and continuing. So if you are original in your intent and originalist as the court proclaims, they have to understand and reckon with the 14th Amendment in its entirety, especially Section 3.
Thank you. Manisha, Harry?
I think Eric wanted to say something, so I'll let him go before me, and then I'll.
Okay, Eric?
Thank you, Manisha. I would just close and say that, I mean, the 14th Amendment is challenging, I think, for non-experts to understand, as several Hillary and Manisha talked about earlier. I mean, teaching it is challenging. I think most Americans, most of our students have heard of the first section. They know the due process clause, and they understand birthright, citizenship, and equality. But I mean, what this brief does, and I think what this case illustrates, is that this the importance that the framers of this amendment placed on insurrection, on treason, on punishing treason is just as important, or just as important as equality, as voting rights, and we shouldn't forget that. And I think that's hopefully what our brief gets across.
Thank you.
And I would say that, going back to this notion that many people have, which is strict construction for me, but not for thee. And it's an old style of reasoning, going back to John C. Calhoun, who was, fashioned himself as the greatest literalist and strict constructionist of the US Constitution, and then invented out of the blue these notions of states nullifying federal laws and federal authority, and even the so alleged constitutional right to secession, none of which are in the Constitution. And I think that style of reasoning stays with some people. They claim to be strict constructionists, but when it doesn't suit them, they're not. So I'll wait and see how the Supreme Court rules on this, and we will know them by their deeds, right? At least as far as Trump's lies about the 2020 presidential elections and about federal authority over the borders recently, with Texas reviving Calhounian notions of absolute state sovereignty. At least in those instances, the Supreme Court has ruled, differently, and not politically. I'm not talking about the other awful decisions that they have made in the recent past. So there's some hope. Let's see how it goes. I mean, at least we had Roberts, and I think it was Amy Coney Barrett, who reasserted federal authority over immigration and our borders. I do think it is important to respect the Constitution in all its parts. And if you have a problem, there is an amendment process there. You cannot get rid of a Constitution with an or a constitutional requirement with an executive order that some people thought was possible. And that shows the cavalier attitude towards our democracy, its institutions, and the Constitution itself. And, in this respect, as Lincoln said, we are the conservatives because we are standing by these age-old ideas and what is actually important in terms of maintaining a constitutional democracy.
Thank you. Thank you so much. Harry?
Thanks a lot. I guess I would close by saying once again how much I believe this brief is excellent history founded on unquestionable facts, a huge number of them. And I urge the country, my fellow citizens, and the justices of the Supreme Court to read the Constitution in its plain meaning. If the court were to ignore the points that are made in the brief and that we have discussed in our conversation now, it would mean, and I think many people have acknowledged that it would mean in a kind of cavalier way, that the court this time has decided in a very instrumentalist way to vote to create the outcome that it wants, and perhaps to invent a justification out of the whole cloth because, hey, you know, come on, they're the court, they sit in the seats, you know, they can do what they want. And I'm very afraid that the court is going to might, let's say, embarrass itself and whittle away at the respect that Americans have for what the court says. Because if people conclude that the court will say anything it wants and institute whatever policy they happen to like, then respect for the court will disappear. And without some kind of respect for the enforcers of the rule of law, we're all going to be very, very much in trouble. You may not respect it now, but boy, are you going to miss it when it's gone. So
that's why this moment is a crisis of legitimacy as well as a crisis of law.
exactly.
And I think it's a crisis of evidence that for the last how many years now, people feel they can just say anything and make it true. And, you know, it even goes back to disciplines and postmodern history and things, that the idea that, you know, we know history is an interpretation, but evidence is evidence-based. And if we can't use evidence, then what hope is there, I think?
Yeah. You know, I would reiterate my warning that you cannot take democracy for granted. And the cornerstone of democracy, as Vernon has pointed out, is truth. Without truth, there is no democracy. Anything goes. You know, for most of human history, rulership has not been the sovereignty of the people. It's been hereditary or by the sword. But the first golden age of democracy was right after World War I, when out of almost nothing, there were 24 democracies. And then by the early 1940s, that number had been cut in half, and most of the destruction had come from within. And now in the 21st century, we are again seeing the diminution of democracy all over the world. In Putin's Russia, in Orban's Hungary, in China, even in India, those who chart these things worry that democracy is on the decline. And let us understand that Section 3 of the 14th Amendment, as understood at the time and in a timeless sense, is a bastion for the protection of democracy, to make sure that those who want to undermine, sabotage, trash democracy don't get a chance to do it again. And in the aftermath of amnesty, we now know that's not theoretical. That's exactly what the former Confederates did for so many decades in snuffing out democracy in the American South. So really, in many ways, the fate of our democratic republic does hinge on how we come to reach a decision about the meaning and scope of Section 3 of the 14th Amendment, and we ignore it only at our grave peril. And I certainly hope that the court will take into account the history that all of us have presented. And I want to thank this incredibly distinguished group of scholars that are here, and those who contributed that are not here. Whatever happens, we will go down in history, I believe.
You know, Lincoln said in that Lyceum speech, I keep going back to, that America would never be defeated or destroyed as a country by outside forces. It would be from within. And this is what he was talking about exactly with the rule of law. I think it's so important. And I really appreciate everybody that worked so hard on this brief, is willing to sign it. And, you know, I am hopeful in another way, though, and that is in young people. Evidence in young people are my hope, that I've seen in court cases. I'm sure you have too, Allan, that judges ruled against what they'd like to because of the evidence. That they were willing
We've seen
to
it too often, Vernon.
But young people, I think, really do not want to see discrimination. I think they believe in these ideals, but of course they have to vote. We see what happens when people do not vote. And I hope I'm right about that, and I think I am. But again, it's going to, we see voter suppression like we have not seen since 1898, as far as I can tell. When I was asked in 2 recent court cases about Alito's Bronovich decision, is it like, 1982? He said, now it's not like 1982. Well, I had to say, well, he was right, because it's like 1898 in Williams versus Mississippi. 1982, everybody was willing to admit with the voting right. Everybody had the right to vote. They may have tried to dilute that vote, make it not have as right effect, but we are back to a situation where certain groups of people are trying to stop people from having the right to vote. And that's frightening. This 14th Amendment is the most important. But when you think about, we grew up, at least my generation grew up with the 14th Amendment doing wonderful things, bringing about extraordinary rights with the Civil Rights Act, with Brown v. Board. But in the last 20 years, it is the same amendment that has been totally misused to get rid of affirmative action, which was there for the 14th Amendment. Is exactly what Slaughterhouse said. It was about to do something about a group of people who had been discriminated against and enfranchised. So it's now being used in just the opposite ways. So it's important people study that 14th Amendment, as you folks have said, in its entirety. It's the most powerful, the linchpin, the most used amendment in the court system. And it should not just be used as it has been the last time I looked at it, 80% of the time, to show that corporations have the rights of people. And if we're going to do that, we can at least stick with Section 3 that's in there.
Well, you all have done a wonderful job of doing the brief and of coming here today to put the brief before the people. So we very much appreciate your doing that, of your going back and raising the voices of the senators and the people on the floor and making those voices a part of, not only reflecting what happened then, but a witness of today, and that link between the people of today fighting for their rights, the people of the 60s, goes all the way back to that period. So everyone will be able to hear those voices because of the work that you all have done with this brief. So I want to thank you for that work. I want to thank you for being here today. Eric Alexander, Hillary Green, Paula Escott, Manisha Sinha, Harry Watson, Brooks Simpson, Adam, who left us a little bit early. Thank you for representing the 25 people who signed on. And then we want to also give our big thanks to Vernon and Allan, who did a lot of that groundwork. So we want to give you your applause for doing that. And again, you are right. You will go down in history because it didn't go by with silence. We didn't put silence in the face of what was happening. Instead,
Thank
not
you
only
for giving us this forum. We really appreciate your going out of your way to bring us together to present this important information to the American people.
well, thank you.
I want to say too, so many people helped in this in terms of sending in suggestions, corrections, typos even. We wanted it right, and so a lot of contributions, just not signing, but a lot of contributions, and thank you all.
Yeah, and as you said earlier, it's not your voices, it's the voices of those people who stood in those chambers, 100 years ago, that you are raising.
The original intent.
Yes, the original intent. So we thank all of you for your work. on Trump versus Anderson. That case is going to be heard oral arguments before the U.S. Supreme Court on Thursday, February 8th, 2024. So those who have not been following know that we have a very quick turnaround from what we've learned today to what decision is going to be made at that time. So I urge you to please share this video with many individuals who are maybe not sure about what the case is about, and why it's important, and why we should pay attention to that case. This is one of the answers. So I thank you again for being a part of this. And, you know, we at Camelot Excalibur Trust, we're going to continue to do the work because you all are doing the work that we want to share. So thank you.
Thank you.
You.
Good
Thank you
night.
for having us.
Good
Good
night,
night.
everyone.
Well,
Bye.
good to see everybody in person.
Indeed. Absolutely.
Thank
Good
you.
night, everyone.
Bye.